the Honorable Minister, Dr. Aaron Motsoaledi, the Deputy Minister, Dr. Joe Phaahla, esteemed officials from the National Department of Health, the Section 59 panel, Chairperson, and the Secretariat of the Section 59, the Deputy Chair of Council in his absentia, and the astute Council members present today, CMS management and staff, led by the CE and Registrar, Dr. Musa Gumede, the representative of healthcare providers and the medical schemes, members of various media houses, ladies and gentlemen, good morning. It is a great honor to welcome you all to this important occasion. We are especially grateful to the Honorable Minister and our distinguished guest for gracing us with their presence today. Indeed, your presence underscores the significance of the release of the Section 59 report and the issues it seeks to address. As a background, around early 2019, there were several allegations made by various healthcare providers and associations, in particular the NHCPA, led by Dr. Donald Gumede, and the Solutionist Thinkers, regarding racial discrimination, unfair treatment, and billing abuse by medical schemes. These complaints were not merely administrative in nature, but spoke to the fundamental principles of equity, fairness, and non-discrimination enshrined in our Constitution, the Medical Schemes Act, and other applicable legislations. In response, the Honorable Minister, Dr. Aaron Motsoaledi, directed the Council for Medical Scheme to investigate these serious allegations. In line with our Council's constitutional mandate, the Council has an obligation to protect and promote the rights espoused in our Constitution, and to implement the promotion of equality and prevention of unfair discrimination, the PEPUDA. And in terms of our legislative mandate, the Medical Schemes Act, the Council has a mandate to protect the interests of the beneficiaries and the members of the medical schemes, to make recommendations to the Minister of Health on the quality of healthcare services provided for by medical schemes, to investigate complaints and settle disputes in relation to the affairs of the medical schemes as provided for in the Act, to advise the Minister on any matters concerning the medical schemes, and to perform any other functions conferred on it by the Minister or the medical scheme. Consequently, in 2019, the Council for Medical Scheme established a multidisciplinary steering committee which comprised of various stakeholders, including representatives from healthcare providers and the medical schemes. The steering committee supported the establishment of an independent investigation to the conduct and an inquiry into the allegations. This process culminated in the appointment of the Section 59 panel, chaired by the Advocate Mugai Toby, SC, and supported by Advocate Adila Hassim and Advocate Kerry Williams, as well as the Secretariat Lawtons Africa, led by Mr. S.J. Tema. Around December 2020, the Section 59 panel released an interim report that provided a glimpse into the systemic disparities and the urgent need for reforms. Subsequent to that interim report, the panel opened another opportunity for stakeholders to make further submissions. That happened in 2021 and in 2023. Our Honorable Minister, Dr. Aaron Motsoaledi, will today receive the final report, a milestone that closes a critical chapter in the inquiry and open a new chapter for policy, reform, and transformation. Council is excited about this event, and we are hopeful that the Minister will also receive an executive summary of the report for ease of reference. In conclusion, colleagues, Council wishes to take this opportunity to extend its deepest gratitude to our Minister, Dr. Aaron Motsoaledi, and his team for his leadership, strategic guidance, and stewardship. We sincerely acknowledge the pivotal role played by various stakeholders who enabled the successful establishment and execution of the Section 59 inquiry. Thank you so much, astute Council members, for your resilience, outstanding service, and invaluable commitment to the governance of the Council for Medical Schemes. And in particular, thank you for ensuring that the release of the Section 59 report materializes. Council further extend its appreciations to the Council for Medical Scheme Management and staff, led by the CE and Registrar, for their continued dedication to the management of the Council for Medical Scheme, and without whom the Section 59 processes would not have been made possible. Thank you so kindly, Program Director, for the opportunity. Thank you.
Thank you very much, Chair. I think now it's clear why. Let me brief history of what has happened. So the main reason we are here is to give advocate and the prudent opportunity to present it. But for the record, he is presenting the report to the Minister of Health in South Africa, Dr. Aaron Motsoaledi, in the presence of the Deputy Minister, Dr. Joe Phaahla. Over to you, sir.
Yes, thank you.
I think you should come.
They are fit advocates. Go to them. They are fixed by the media, otherwise you'll mess up their careers.
The stage would then come with me.
Yeah. Yes.
I think SJ there should sit,
Yeah.
because he's my attorney in this.
No. Please pass here.
Yeah.
Yeah. Take that here. Thank you. Let me touch base here.
Yeah. right, thank you very much.
Yes.
Yeah. Thank you, Minister. Dr. Motsoaledi and Dr. Patha, I'm pleased that you've attended a session where I'm speaking. And it's not a court of law. I'm also grateful to Mr. Gumede, who is the registrar, and Dr. Thandi Mabeba, who is the chairperson of the CMS. Dr. Gumede. Oh, yes, I did ask whether it's Mr. or Doctor. I was told it's Mr. So, I don't know, someone was undermining Dr. Gumede. I apologize profusely. Yeah. There are also other names that I should thank who have helped us to get where we are. Dr. Mini, the late chairperson of the CMS, Dr. Kabane, who was the registrar of the CMS, Dr. Makiwane, who was the chairperson of the CMS, Ms. Grace Koza. So those are some of the people that have helped us to be where we are. We've come today to hand over our reports, both the interim and the final report, to the CMS and the Minister. But I should just give a summary of the background as well as some of the key findings in the reports. Some of this has already been given by Dr. Mabeba. This all began in 2019 when a number of healthcare providers and members of Solutionist Thinkers, which is an organization in the space, and the National Healthcare Professionals Association, which is also another association in the space, they made allegations that there was unfair treatment by medical aid schemes, which was based on race and ethnicity. Those allegations were referred to the Human Rights Commission, which began its own inquiry. They were also simultaneously referred to the Council for Medical Schemes, which took a decision to investigate this in terms of its regulatory mandate under the Act. This then led to the establishment of an independent investigative panel to conduct an inquiry into these allegations. This is what has become known as the Section 59 inquiry. I am the chairperson of that panel. There are two other advocates that I worked with, Advocate Adila Hassim SC and Advocate Kerry Williams. Dr. Kimi was our expert. The Human Rights Commission, as I understand, paused its inquiry in view of the CMS initiative. The panel was also supported by a secretariat, primarily the law firm Lawtons Africa. Mr. S.J. Tema, who's sitting on my left, was the leader of the secretariat. There have been other attorneys before, but there's now Mr. Ngosi, Mr. Sipongosi, and Ms. Shannon Etta, who were also part and parcel of the secretariat. So I just want to thank them as well for the sterling role that they played in assisting the panel. We published an interim report in January of 2021. And after we published that report, we decided we wouldn't make it final. We would make it provisional and still entertain submissions from the sector, which was quite an elaborate process on its own. But the final report is dated the 25th of April 2025, which we submitted to CMS. And that is the report we've come to unveil today. Just to make it clear, we were investigating two areas. One is what we classified as procedural fairness. The second is what we classified as substantive unfairness. In other words, whether there are systemic patterns of discrimination on the grounds of race and ethnicity. So I want to start with procedural fairness. We made certain findings in the interim report on procedural fairness, essentially to try and find out whether or not the procedure that is followed by medical schemes when they implement what is called FWA, fraud, waste, and abuse, is fair, whether that process is fair. In other words, regardless of whether it's racially discriminatory, but whether or not it's procedurally fair. And what we had found in relation to the procedural fairness was that the FWA procedures for the recovery of monies allegedly owed is unfair, and it violates the rights to procedural fairness of individual practitioners. We found that the schemes should make changes to the manner in which they claw back monies that they claim practitioners owe to them. That was our interim finding. We've received further submissions, but we remain unpersuaded that our interim findings were incorrect. Accordingly, we confirm the findings and recommendations in the interim report that the procedure that is followed by medical schemes when they claw back monies allegedly owed by practitioners or where they investigate instances of fraud, waste, and abuse are unfair. The unfairness really revolves around the rights to procedural fairness of individual practitioners. They also revolve around the decision-making by schemes, which is not detached and not independent. They also revolve around the power imbalance between the schemes and the individual practitioners. So on those three aspects, we have found that the current procedures that were at play as at 2019, which was the cutoff date for our investigations, violate the right to procedural fairness of individual practitioners. And as I say, we've considered in detail the explanations and the justifications given by the schemes, but we have not changed that finding. We've made certain recommendations that the schemes can consider, and maybe the minister can consider in relation to any possible amendments to the Act, because part and parcel of the problem is that the Act doesn't actually contain procedures for the administration of fraud, waste, and abuse, nor do the regulations. And so what they do effectively, they leave it up to the schemes to make individual decisions about how to claw back or how to investigate or how to impose penalties against allegedly errant practitioners. The first one is that we say that the schemes and administrators should develop an early warning system whereby schemes notify providers as soon as the schemes become aware of any circumstances which might lead to the application of Section 59, subsection 3 of the Medical Schemes Act. Such an early warning system will not only prevent prejudice to providers who may innocently be engaging in wasteful behavior, but will also benefit the schemes as providers engaging in abusive behavior are likely to adopt corrective measures rapidly, thereby preventing further or ongoing loss to the schemes. Now that's important because most of us were here during the public hearings will recall that the schemes argued that there are basically billions of rands that are spent every year and wasted in abusive practices by healthcare providers. But on the other hand, healthcare providers are saying it's unfair the way in which they are all accused of certain practices by certain individuals. So they disagree with that blanket approach. So we recommend strongly the early warning system, which will give individual practitioners an opportunity to show that even though in the sector there might be an abuse, the individual practitioner is not implicated in it. Number two, we say there is a need to review the audit and clawback time period. Now, the problem here that we found is that sometimes a medical practitioner would blissfully carry on with their practice, and then 3 years after the alleged incident, there would be a clawback, and that clawback goes back 3 years earlier. So firstly, you learn about it 3 years after the event, but the money is to be deducted, in the last 3 years. So we say that clawback period needs to be reviewed. That again could go into the amendments to Section 59(3) of the Medical Schemes Act, particularly around the historic years and the period of 3 years, whether or not there is justification for such a clawback period. And we say there are times where the period and the clawback causes unjustifiable hardship to providers. We had terrible evidence here about medical providers that are forced to close down their practices because they simply cannot afford to carry on if they are not supported by medical aid schemes. And in circumstances where they have to pay back the money that has been clawed back by the schemes, some of them can't even afford to pay for their families. We say that the problem with that system is that it lies in the structure of the Act that doesn't contain detailed procedures for the process that must be followed if there is a suspicion of fraud, waste, and abuse. But we also accept that there are times where a clawback may be necessary to protect a scheme, because the nature of the scheme is that it's a collection of monies coming from the members, and those monies must be protected. But we think that the current system is not balanced enough. We think that the current system is disproportionate in the way in which it allocates power to medical schemes and disproportionately impacts individual practitioners. Number three, we say there should be a mechanism to assist providers when engaging with the schemes once a provider is accused of conduct which amounts to fraud, waste, and abuse. Now, here again, there was a lot of evidence that we had in which a scheme goes into a discussion with a provider, sometimes supported by a lawyer, sometimes supported by an investigator. But the provider is isolated and has no way of defending themselves, and they end up signing acknowledgements of liability or acknowledgements of debt in circumstances where they don't have sufficient representation, to defend themselves against the power of the scheme. And at the same time, there is this dynamic of mutual dependency, that the provider depends on the scheme to, pay for their ongoing expenses. But when the investigation is conducted, we found that the atmosphere can be intimidating, particularly in circumstances where the individual practitioner has no representation. So again, we say that is up to the stakeholders to work out how exactly that representation can be provided. But one of the suggestions we have is that there should be a tribunal that may perform this role. We had heard that there were already attempts at CMS to initiate a tribunal of this nature. If those attempts are already underway, we would strongly recommend. But at the time we did the investigation, we started the investigation in 2019, there was no such a tribunal. And the power imbalance played itself out, particularly in the way in which the investigations were conducted. Number four, we say that there should be a complete transparency regarding the software the algorithms and the artificial intelligence programs that the schemes use to monitor claims made by providers and members alike. If the schemes persist with the argument that they will not allow this transparency because it will undermine the detection of fraud, waste, and abuse, then we say the Council for Medical Schemes must introduce a mechanism where it, in other words, the Council itself, has full transparency relating to the software, the algorithms, and the artificial intelligence programs that the schemes use. The schemes ought to be accountable to a public body for the systems they use, as this in turn ensures accountability to the public whilst maintaining a form of confidentiality which we understand to be necessary to ensure the effectiveness of the algorithms or programs. I need to explain this a little bit. Most of the evidence we had was that there is a software program that the schemes use to detect fraud, waste, and abuse. But there is no transparency in relation to the input into that software program. And then the argument is made that it's that software program that produces the results of fraud, waste, and abuse. And because it's an invisible program, it's impossible to work out whether it's discriminatory or not in relation to its outcomes. But that explanation actually reveals the problem, that no one has any idea of the algorithms that are deployed by medical schemes to detect fraud, waste, and abuse. And the government is not monitoring this, Minister. Government is not monitoring this at all. The Council for Medical Schemes itself has no access to the input that goes into this supposedly neutral algorithm. And yet the impact that it has on individual practitioners is immense. So if this will not be achieved voluntarily, we suggest that the legislation should be amended in order to make it compulsory that there should be such a transparency. We made recommendations in our interim report. We've affirmed those recommendations, and the 4 that I've outlined here are new recommendations that have come in the final report in relation to the Section 59 procedures. So we say all of these recommendations relate to the particular areas where the CMS may wish to make proposed changes and or additions to Section 59, subsection 3 of the Act. So this one should read CMS and or the Minister, because the Minister is in charge of the legislation. It appears that the section that gave rise to the fraud, waste, and abuse systems is light on regulatory detail and could be expanded upon so that it properly regulates the more intrusive aspects of the FWA systems developed by schemes and their administrators over the last decade. So the legislation is lacking. It has several gaps. It's not keeping up with the technology, and the legislation must catch up with the technology. We say that the CMS, as the regulator responsible for the implementation of the fraud, waste, and abuse systems, is required to ensure that schemes and administrators act procedurally fairly. It is within the CMS's discretion as to how it chooses to progress this object with various stakeholders, bearing in mind our findings and recommendations. So that is what we say on the process issue of Section 59, subsection 3. We make the finding that the procedures are unfair, and we make the proposals about the improvement of the regulatory processes. Now let me then deal with the issue of the discrimination. Now the people that are here will recall that in our interim report, we found that there was unfair discrimination on the grounds of race, which was prima facie in breach of the Equality Act and in breach of Section 9 of the Constitution. We have gone to great lengths to explain the evidence which the panel assessed to decide if the fraud, waste, and abuse systems as implemented between 2012 to June 2019. Maybe I should have explained that earlier. The period we were reviewing is 2012 to 2019. We did not look at the period beyond 2019. whether that caused discriminatory outcomes or resulted in unequal treatment. The methodology that Dr. Kimi developed is a useful tool for all stakeholders to measure the performance of the FWA systems and to keep track that they do not cause discriminatory outcomes or unequal treatment. In relation to the historic period 2012 to 2019, we have found that the schemes have not materially disputed the risk ratios that Dr. Kimi calculated in his third report, which are contained in Annexure A of the report. I'm not sure if the Minister will release the report to the public, but we would recommend that he releases it to the public immediately so that there is no issue, but that's outside of my jurisdiction. But if you do get access to the report, you must look at Annexure A. It further seems that calculating an overall risk ratio for the period between 2012 and June 2019 for all the schemes and administrators is not the only useful measure of discriminatory outcomes. It seems equally useful to assess the scheme's performance on an annual basis for each discipline. So let me just explain this a little bit. I mean, what we found ourselves in a sort of disadvantage because we had to look at a very long period, 2012 to 2019. But if you are interested in measuring discriminatory outcomes, we would suggest that you do this on an annual basis, that every year you look at your results in relation to the racial risk ratios about who has been investigated and what is their racial profile in order to monitor the performance of the schemes on a racial and ethnic basis, so that you don't wait for a 7-year period and then you say, well, over 7 years I have found that there has been discriminatory outcomes. We say you have to do this because the results will reveal how practitioners in each discipline, and again you have to separate them per discipline because you may find that other disciplines have got a higher risk ratio than certain other disciplines, and then you have to find out why, what is the cause for the higher risk ratios in specific disciplines. And so we say that will be a good measure to monitor the effects of the investigation into fraud, waste, and abuse, particularly on black healthcare providers. And we say that if you do not break down the risk ratios in this way, it is possible to lose sight of the years where discriminatory treatment may have been particularly acute, and further to lose sight of the disciplines in which black providers experienced more discriminatory treatment. Equally, the breakdown of the risk ratios also shows the disciplines where there was no discriminatory outcome. So we are recommending a more scientific approach to this. Otherwise, I mean, what we found was that basically the report we did was the first time this topic received in-depth attention. And it was a long period of time, and there was just so much data to plow through. But if you did this on an annual basis and you divided it, you'll find that the data you are working on is actually manageable. We have already attached the risk ratios per year and per discipline in Annexure E of our report, and we point out that from these risk ratios, it is evident that for a number of years and for a number of disciplines, the risk ratios were extremely high and certainly not close to 1 at all. For example, and we only mention a few examples, but there are many more examples if regard is had to the risk ratios in Annexure E. So let me just deal with the specific schemes then. And this risk ratio is basically a tool that we developed to work out the likelihood that a black practitioner would be subjected to an investigation, a finding, and a penalty versus a white practitioner. And black is a generic term that includes coloreds, Indians, and Africans. For GEMS, black dental therapists in 2014 experienced risk ratios of between 2.7 and 3.7. In other words, they were generally approximately 3 times, 300% more likely than non-black dental therapists to be guilty of FWA, fraud, waste, and abuse. So they were more likely to be investigated and found guilty of fraud, waste, and abuse 3 times more. For Discovery, black psychiatrists in 2017 experienced risk ratios of between 3.44 and 3.77. In other words, black psychiatrists were generally approximately 3.5 times, 350% more likely than non-black psychiatrists to be guilty of fraud, waste, and abuse. For MedScheme, black anesthetists in 2018 experienced risk ratios of between 6.39 and 6.78. In other words, black anesthetics were generally approximately 6.5 times, 650% more likely than non-black anesthetics to be guilty of fraud, waste, and abuse. We note that all of these risk ratios are probable risk ratios. As explained above, we do not need to make scientifically certain determinations of the risk ratios. Findings based on what is probable is enough for the purposes of this final report. These probable risk ratios only relate to the historic period, the period between 2012 and June 2019. The panel cannot and does not comment on any conduct of the schemes or outcomes for black providers since June 2019, because those were our terms of reference. We were cut off in June 2019. The methodology developed by Dr. Kimi to measure any discriminatory outcomes by the schemes and administrators, we repeat, is a useful tool. Breaking down the risk ratios on an annual and per discipline basis is also a useful tool. It has the potential to give all stakeholders a clear view on whether black and non-black providers are being treated equally each year and in each discipline. The expert evidence that the schemes provided and the administrators provided does show that there is scope to improve the methodology that was used by Dr. Kimi. We recommend that they continue to work together on those issues. Let me make one qualification to these findings. We were not a court of law. We were not adjudicating individual complaints. We did not sit in a trial. We did not have to make legal findings applying the Promotion of Equality and Prevention of Unfair Discrimination Act or applying Section 9 of the Constitution. But what we did have the power to do was to make findings of fact. And that finding of fact simply leads to one conclusion. The evidence of the risk ratios before us showed racial discrimination against black service providers by the schemes. Let me repeat this. We were not a court. We did not adjudicate individual complaints. We did not run a trial. We did not make legal findings about unfair discrimination in terms of Section 9 or the PEPUDA Act. We only considered the facts. The facts lead us to one conclusion, that the evidence of the risk ratios before us shows racial discrimination against black service providers by the schemes. We have explained that the tool that has been developed by Dr. Kimi should be continuously improved, but it is useful as a starting point. We have also recommended an annual assessment of the impact of FWA on black providers. We have also recommended the splitting of specific disciplines in order to monitor the instances of FWA among the healthcare providers. The specific recommendations you will find contained in the report, but those are our findings based on the facts. We have considered in detail all of the explanations and the expert reports that has been given to us by the schemes. They were not sufficient in our respectful view to displace the findings that on the facts, the risk ratios show racial discrimination against black service providers. Dr. Motsoaledi, it is now my great pleasure to give you Three documents that my attorney has given me. So document number one is the
I think the optics would be better if you hear.
optics. All right. Oh, okay.
And the voice is
Then there's no voice.
Oh,
Maybe we'll just continue. I think we can. Minister, the first document is the summary of the interim report dated the 19th of January 2021. The next document, which is the interim report dated the 19th of January 2021. And then the final document, this big dossier, is the final investigation report dated 25 April 2025. This now finalizes our job. I think we can.
Thank you very much, Advocate. Very appreciate it. The next thing now is for the Minister, Dr. Mtsoaledi, to respond. Thank you, sir.
The Reuters Live.
Director, my colleague, the Deputy Minister of Health, Dr. Joe Pasha, the Chairperson of the Council of Medical Schemes, Dr. Mabeba, the Registrar and CEO of the Council of Medical Schemes, Dr. Gumede, and the Chairperson of the Section 69 panel, Advocate Ngwaitobi, and your team. Ladies and gentlemen, thank you very much. I wish to inform you that, well, I'm sorry, they were just showing me that I had an omission of the Section 59 Secretariat. I'm sorry about that. Yes, yeah. I wish to confess to you that the reports given to me by Advocate Ngwaitobi, I'm seeing them for the very first time with you. I deliberately, from April, did not demand to see the reports because I wanted them to be as neutral and as fair as possible without any sort of what people will call political interference. I'm sure Advocate Ngwaitobi can confirm that there was no political interference on any of the things that he has done. So I deliberately stayed away. For that reason, my confession means when you ask questions, don't expect me to comment much about this report. What I know is what I've heard with you now. I can comment on that. But we are going to have time to study this report thoroughly and make a statement, official statement from the department. At the moment, we'll just make some snippets. For instance, Advocate Ngwaitobi gave me a very big problem. And I thought that problem is not for ministers or doctors, it's for lawyers. He should have guided me on what to do. He said I must release this report immediately, meaning that I must release it even before reading it, which implies that some of you who are fast readers can finish before me and start firing me with questions while I'm still struggling through. But because it's an instruction from senior counsel, I'll carry it through. Senior counsel, I'll release it and try my best not to sleep, to read as fast as possible. Having said that, ladies and gentlemen, let's not undermine the immensity of this. You will appreciate the fact that when the complaints came, I was the Minister of Health. I appointed this committee. Then I left the department for 5 years to to come back to find that the committee is just finishing their work now. So it means it was quite extensive. It's like the health market inquiry. For those who remember, when we started the health market inquiry, we gave them 6 months. But it took 5 years because of what was coming out, the interest, even outside the borders of the country, where people have to come in. I'll believe that this is more or less the same thing because of the sensitivity of this type of matters. Advocate, I accept the criticism, perhaps of the Act and the weaknesses in the Act. But you will realize, ladies and gentlemen, that the manner in which the private sector came into the country was never planned and designed. It just evolved. It just evolved. I was a GP, and I left in 1994 to go to government. There was no Council of Medical Schemes Act. I mean, this Act, which came in 1998, was not there. And when you look at how the system evolved, Advocate, for instance, when I was a GP, I started in 1986. Patients were not required to sign anything. You just see your patients. In the evening, when you have knocked off, you take the forms you claim and you send to medical schemes. Why was it like that? Because when this system evolved, nobody was expecting human beings to commit fraud. We're expecting honesty at all times. So the laws kept on piling one on one, because after that they then said, no. Doctor, you can't send any claim without the patient signing. We had to get the patient signed. And in some instances, it was discovered that patients were signing a blank form, and the doctor comes and fills everything. So they had to change the laws again. Even things like PMBs, prescribed minimum benefits, which are also causing the problems, they were not there. We were just claiming anything you are claiming for, you got paid. Now, when the situation became tighter, medical schemes trying to defend themselves, to protect the public, they came with PMBs, the prescribed minimum benefits, forcing medical schemes to pay for certain diseases but not others, for certain diseases which they regard as serious diseases. That to me as a doctor is a problem, because every patient who is sick regards their disease as serious. You can't tell a patient that no, your disease is less serious than this other person, so you are not going to be paid for. It's not fair for patients. But all these were attempts to try and contain the situation which is not, which cannot be contained. I was in London last week when Power FM phoned me to inform me about the Board of Healthcare Funders, which represent medical scheme, and Health Funders Association, going to the Supreme Court of Appeal about the LCBOs, the low cost benefit options, because they asked the Council of Medical Scheme allow us to do low cost benefit options, meaning what? Allow us to pay lesser for certain disease or not to pay at all, away from the PMBs. And of course the matter went to God. The judge ruled against them. And I suspect that judge was understanding the value of health to human beings. But they were fighting. And I knew exactly why they want to go up to the Supreme Court. They will even go to the Constitutional Court. It's because they want to dodge the PMBs. Yes, they want to dodge paying the PMBs. In other words, they want to dodge paying for certain diseases and give it to the doctors. Some of the doctors may feel, oh my God, no man, I'm not going to be chasing patients. Let me take a shortcut. I'm just explaining, not to justify that some of them are forced into that. So the low cost benefit options, which are going to the Supreme Court of Appeal, are not low cost benefit options. They are low cost, low benefit options. But that low benefit is not being mentioned. And part of it is, you know, so what it means is you need an overhaul of the whole system. That's what I'm trying to say, Advocate. And I agree with you. We need to look at, and you can throw into the mix the issue of the NHI, which is trying to solve some of these things, which is also in court, by the way. You know, and there are already 6 court cases that we sort of dealing with. So we are going to look at this whole thing holistically, not piecemeal. Because if you do it piecemeal, Advocate, we are going to call you again after 7 years to invest something. So we have to look at it holistically. How do we resolve the whole healthcare system of the country in such a way that it's fair? I have been under pressure from black doctors. They've been complaining that we're not taking care of them, they are suffering. You can imagine having to close your practice because, you know, a certain amount of money is demanded of you, which is so huge that we have got no other way but to close, or not being paid by medical schemes, having only to take cash from people who really don't have that much cash. So the whole system is going to be reviewed. We have got now 2 very important reports. We have got the Section 59 investigation report. We have got the health market inquiry. We have got the NHI Act. We have to find a way how they cross each other, or how they strengthen each other, or how they try to work with each other to solve this problem. So it's still a lot of a way until we're able to find the system correct. But be that as it may, thank you very much. We are relieved. I'm sure those who made the allegations are also relieved that they've been proven to be right. Advocate, is very painful, by the way, that now we are dealing here with racial discrimination so many years after 1994. It's very painful. And I was reminding people that back then, before 1994, many might have forgotten, we had 14 departments of health in this country, with 14 ministers of health. If you think back, it was the 14 departments of health with 14 ministers of health, the 10 ministers of the homelands, the minister of white healthcare system, Indian healthcare system, colored healthcare system, and somewhere in between. We abolished that through our constitution, the interim one in 1993, and the final one in 1996. We abolished that. We are waking up today, by the way, after abolishing that, to find that we are running 2 healthcare systems in the country that are like chalk and cheese in the way they look like. This is what brought us here. We are running 2 healthcare systems. One for those who are well-to-do. The difference is that those who were in the black part before have been co-opted, yes, to join them against the poor. And when we mention these, people do not understand it. We don't want 2 healthcare systems in the country. Otherwise, we'll keep on having this type of problem. Now, within that, those 2 healthcare systems, one is for the well-to-do. And every day we are being told, Advocate, that leave it alone, there's no problem there. Go and fix the mess in the public healthcare system. Leave this one, is doing very, very well. I don't know what today you're saying about that. Because we've been telling them, we are not attacking any one system. We simply don't want 2 different systems. We want the population of South Africa to be able to have access to all the healthcare providers and all healthcare systems in South Africa. And it's not true that the well-resourced private healthcare system has got no problems. This is just one of them. And it's the worst problem ever, that of racial discrimination, many years after we have got a new constitution. So you can't expect us to fold our arms and say, no, one system is okay, it's perfect, we must go and fix the other. We want to fix both. And that's how the NHI Act has been, we've tried to design it. But anyway, as I am saying, When we are ready, after having studied this, we'll issue an official statement to the public about what the department say about this. These were my preliminary observations after I received this report. Once more, Senior Counsel, thank you very much. But don't expect, you said it's the end of your work. As you handed the report to me, it might not be, because somebody might decide to take it on review. They usually do that. Even the health market inquiry, the report came in 2019, we are still being threatened that it may be taken on review. And the threat of taking it on review only comes when you want to implement it. So if I take it, I go and peg it in the cupboards, there might not be a review, but the day I start implementing your recommendations, you might expect a review. We might go to the courts and call you where you are outside the courts and say, come back, there's a problem here. Otherwise, thank you very much.
Thank you, Minister. Yeah, is that time your question and answer? And the technical team tells me if you are going to ask a question, you're going to have to move to the front, you know, and yeah, for technical reasons. So I'm going to ask all of you who want to ask questions just to move to actually to work well. Just come closer here, and then, as you know, you will identify yourself, the media houses, and indicate to whom you're asking the question. Don't forget, I must remind you that the minister has not read the report, you know. So just ask the question, and that the advocate wrote the report. So, yeah, that is the time. And Matthews, you'll help me with the online questions, né? Yeah, can we come forward with this? Yeah, even the others can move so that you save time. If you know you're going to ask a question, just
You allow the advocate to come this side. He's going to be answering questions. We'll just have to shift chairs.
I think you should come now.
Yeah.
So, let me sit here. No, the first one.
Wait a bit, sir.
Yeah.
This is a press conference. A press conference is for the media. Yes. Press conferences are for the media. I can already guess and see that there are people from the sector advocating.
Oh.
Yes.
Oh.
Yes. They will reopen the investigation, honestly, because they are affected. And press conferences are not conducted that way. The press conference were giving the media a chance to ask questions in order to report. You are going to receive this report when I give it to you. You will then write your comments in it. It will be called. You can't be asking questions today. Otherwise, you will just open the investigation and ask the advocate, why did you make this finding? What did you use? Why, you know, so it can't go on like that. No. Don't shake your head, Chief. Press conferences are conducted like that. And this is a press conference. No, you have to. You have got no option. Yeah, sure. Yes. You have got no option. You have got no choice. This is a press conference. It's for the media. If the media doesn't ask questions, let me tell you, we're not dismissing you. We are going to have a very long session with you about this after the report. The recommendations, we can't just do them alone. We are going to call you the sector, even the complainants. So you are going to have your session, and a very long one. Today is not your session, it's a session for the media, to be able to explain to members of the public who are not here with you, who do not know these things like you. So please respect that.
Okay, thank you very much. Yeah, we'll call it a media conference. No, it's not a press conference. Okay, thank you.
Thank you so much, Peter Molemani, Kaya News. One question to you, Minister, and another one to Advocate. The last one to the CMS. Minister.
Risk of committing fraud because of the unfriendly software system within the medical aid. what does this minister ask you to do? How do you feel about this, Minister? Again, discrimination, race issue in a democratic South Africa. This should be bad from where I'm sitting, but I don't know from you, Minister. Advocate, the fraud that you witnessed or you've got evidence about, any chance of putting the lives of the patients at risk? Any evidence that was submitted to you to say that there were incidents where
Chair, where do you see the CMS, or what is the CMS role in the NHI? Does the CMS support the NHI, and then having the NHI, how is it going to help, especially from the CMS itself? Thank you.
Good morning. It's Domozo from Newsroom Africa. Also 3 questions. One for the...
But I don't see what you call him. How are you listening to us, Newsroom? I've been looking around. I realized that you are missing here.
That's the technical team. All I know is we are getting the information.
Okay.
Minister, so first question is to you. You alluded to then these reports that you have, giving a bigger picture of what needs to happen in healthcare. We've seen over the past few weeks as well what's going on with some organizations stopping what they call illegal immigrants from accessing free healthcare. So what is the balance between NHI and this report in terms of finding fast solutions to making healthcare affordable across the board for South Africans? For the advocates, I wonder if the report made any recommendations on the consumer side of things. Of course, when we started hearing these allegations and these reports were happening, a lot of patients were forced to pay cash because they black practitioners wouldn't get their money back from medical aid. So in terms of that affordability and the impact of affordability over the past 5 years, do we have any insights on that? And how fast do we need to act? Because we are acting retrospectively, as we said, it is a few years back, so that we don't have the same issue 5, 7 years from now as well. And also then to Chair Thandi, just making healthcare affordable and the role that CMS does play in doing that and ensuring that medical aids do come to the board where South Africans don't have to rely on medical insurance alone to be able to afford quality healthcare. Thank you.
Good morning, Nokukhanya Mdambo from Eyewitness News. I'm partly covered by both Pitso and Dogozo, but just to add a few. Advocate Mngwetobi, if you could give us a sense a bit more in depth, please, on the algorithm itself. You said the bias is not necessarily in the algorithm that's used by these medical aid schemes in their probe. So where exactly is it then, and how do you work going forward in making sure that it doesn't infiltrate or filter through going forward? The second one, apologies, is just around, please, if we could also just get clarity on why only just the 3 medical aid schemes, it's Discovery, MedScheme, and GEMS. Did you find any need during the probe to expand it to include the rest of the other medical aid schemes, or was it only based on the complaints that you got back in 2019 that didn't require you to expand the probe? And then in terms of the recommendation, please, you mentioned reforming Section 29, Section 59, apologies, and maybe that's for the minister as well. what would it look like? And is it only just Section 59 from a legislative perspective, or is there anything else for the medical aid schemes for themselves that they're able to reform so that they get up to scratch and we don't constantly see this? And then a last one, again, maybe for Advocate Ngwaitobi, you said it wasn't necessarily from a legal perspective, but collectively, for the people that did come forward with complaints, is there room for them to take forward a civil matter against for the discrimination? Thank you.
Okay, sure.
Thank you very much. The first two questions were directed at the three of you, and then I think the last one is maybe we should ask Dr. Mabeba to start, and then the advocate will follow, and then the minister will follow.
Thank you so much, Program Director. The question that came.
Oh, no, you need the mic. That mic. Put your phone.
Yes.
Thank you so kindly, Program Director. The question that came to us related to whether or not the Council for Medical Schemes supports the National Health Insurance and how it will assist the CMS. Colleagues, you would remember that one of the mandate, or first, before I talk to the mandate, is to indicate that the Council for Medical Scheme is a creature of statute. It is created by the Medical Schemes Act, and one of the legislative mandate of the Council is to, for instance, advise the Minister on policies or on matters relating to the private sector. It also is to support the national policies. So to answer the question that was posed by one of the media houses, indeed, the Council for Medical Scheme supports the national policy, which is the National Health Insurance. The next question was asked from the journalist from Newsroom that spoke to how CMS will assist or ensure healthcare affordability. The Council for Medical Scheme is a regulator to the schemes, and it is actively engaged in ensuring that the benefit packages that are afforded to the members of the scheme are affordable. We deal with various benefit option proposals from various schemes, and we get benefit packages, or we get to approve benefit packages that are low in terms of payments. However, as I've mentioned, that any benefit that is provided to a private patient or members and beneficiaries of the medical schemes must comply with the provisions of the Medical Schemes Act. And one of the critical provisions in the Medical Schemes Act is the provision of the prescribed minimum benefits. We do have low-paying schemes, but it is the mandate of the Council to ensure that these benefits are benefits that are meaningful and covers the health of the beneficiaries and the members of the scheme. Thank you so much.
Yeah, thank you. Okay, there's either something wrong with me or with the microphone.
Oh,
All right, okay. Yeah, thank you. So let me just start with the issue of the, I suppose the first two questions are really the same, because the one is any chance of putting the life of patients at risk. The other is can you give us insights on the consumer side of things? I mean, that's the same thing. What we found, I mean, there were doctors that came with their patients, right, to say that our concerns are not just our concerns, but they're concerns of our patients, because we're just a conduit through which patients receive health care. So the impact on patients is immense. You know, if you are told that you cannot see your doctor except if you pay cash, I mean, that effectively is exclusionary. It means you simply cannot access health care at all, because most patients simply cannot afford to pay cash when they are on medical aid. You know? So it's a blanket exclusion if there is an incorrect decision that your specific provider should either be blocked or should be investigated, or there should be a clawback. So we found that risk very, very high. Now, in some instances where a patient is told, well, you pay cash now, they will change the doctor, you know, which means you close your practice because your practice is 100% or 90% dependent on the medical aid. And then you are told, no, sorry, no medical aid will take you. What do? You know, you close the practice because your patients leave you. They find other people that are not blocked by schemes. So we found that impact to be quite severe. I mean, the other problem is, you know, what happens, I mean, you must have in mind the isolated doctor that's investigated by a scheme that employs an investigator, a lawyer, sometimes a retired policeman, to do an interrogation. You know, and then the options given to the doctor being, it is either you sign an acknowledgement of debt or toast, you know, or we don't pay you. And at that point, they sign the acknowledgement of debt. But signing that acknowledgement of debt also means perpetual indebtedness, you know, in which you can never actually sustain a practice. You know. So it's actually quite a severe impact that it has on the practitioner and on their patients as well. And so we have said in the report that quite a lot of these changes are to be changes made internal by the schemes themselves. But you know, I think that if you live in South Africa and you say, okay, go and change yourself, I mean, you should be very naive. And that's why we say, well, the problem is here. It's the minister has the power to change this. It's also here. The scheme has the power to regulate this. And why are they not doing it? You know? So that's the question we've asked in the report. So, well, they should actually start the regulation because they've got the power under the Act. You know? And if the Act is deficient, as Section 59.3 is, we say, well, change the Act. You know? But what is intolerable is racial discrimination. So that's what we've said. Now, Nogukanye, you've made a very interesting observation about the algorithm. Now, the algorithms are these things that appear like neutral. You know, this is all like technology-driven, etc. But the problem that we've pointed out is that we have no insight into the input into the algorithm. No one has any insight. Even the minister doesn't know what goes into the algorithm, but he is the regulator. Even the CMS doesn't know what goes into the algorithm at all. And that is why we say the first thing is transparency into the input into the algorithm. And if I sounded like I was saying the algorithm is neutral, that's not what I was saying. I'm saying we don't know if it is neutral or not. What we know is that we have no insight into it. And that's why we're calling for transparency into this algorithm. Then the problem is not just the algorithm. You know, it's the algorithm plus human contact. Because the algorithm shows you patterns. You know, too many claims coming from Durban South. You know, too many claims coming from Sandton. And then that gives you an indication that, okay, you should concentrate your resources of investigation here because that is where your greatest area of risk is. But it's still the human interaction about, should I now investigate Dr. So-and-so, or should I investigate Dr. So-and-so, right? And then once you get into that, then they make decisions about where they should go and they should not go. I mean, we found extreme examples of one instance in which I think it was GEMS, that they decided that they are going to focus on KwaZulu-Natal. And once you make that decision on focusing on KwaZulu-Natal, where there is a high concentration of Indian doctors, it's inevitable that you're going to find a spike in the investigation specifically of Indian doctors. But that's because the board set, or if it's not the board, a committee set at GEMS and made this decision. Right? So it's not always the algorithm, it's algorithm plus human interaction. But in addition to human interaction, in other words, the indicator of where you should investigate, there is still the method of doing the investigation. How do they deal with a white doctor in the course of questioning or interrogation versus how do they deal with a black doctor in the course of investigation and interrogation, right? And that's where you find that there's a sort of racially loaded methods of investigation, and then again, those are people doing them, so it's not just a neutral algorithm, But again, it's the absence of regulation, because we never really ask, not to say we, the council, never really ask for detailed reports and the transcript of the interrogation. What actually happened? Did it remind you of the apartheid-style interrogation, or was it actually a fair interrogation? And that's why we ask for a tribunal. That it's the tribunal that must oversee the nature of the investigation. So these are the things we said. What we have had is enough to indicate that there is a problem here, and the problem is racial discrimination. We have to call it racial discrimination. Otherwise, if you sugarcoat this thing, you end up not doing any actual reforms. Then you are right about individual disputes, and this is very, very important. A lot of doctors came expecting us to adjudicate their complaints. We can't. We have got no power. What we are looking at is the system, is the structure, that the system and the structure is producing racially discriminatory outcomes. Now, the individual doctor must decide what to do about their specific case, because what we found is that a doctor will come and raise their story, and then the scheme will also come with their own defense about the specific. Now, imagine the number of doctors we had. If we actually had individual complaints, I know people say, okay, you've taken 4.5 years. We would have probably taken 8 years, so this would never have come to an end. But for us, that's not relevant. What's relevant is that there is a systemic racial discrimination. That's what we found, systemic racial discrimination, which means it must be solved by regulatory improvements, which must be initiated by the scheme, monitored by the scheme, and where they need legislative changes that we have recommended, they must ask the minister for permission. Now, do the individual practitioners have a right to sue? I don't know. I'm not here to give legal advice. I was just an investigator here. But they should go and ask their attorneys and their advocates. Yeah, but I can't make that comment.
They want free consultation.
No, I can't make that comment. It's possible that they do, but it's possible that they don't. I just don't know. But that's also not my function. Okay, SJ wants to say something. Oh, yes. Why did we focus on 3? Yeah, that's again, how many are there? 70 medical schemes in this, 71, like 71 medical schemes in this country. Yeah. So we had to look at the market, like the size of the schemes vis-a-vis the market. These are the 3 largest schemes that cover, I think, more than 80% of the insured market in South Africa. So if we get the facts right there, those facts are indicative of the market patterns. Because we're not looking at individuals, we're looking at the patterns. But the other reality is that I think probably 99% of the complaints related to those 3 schemes that we had to deal with. So it was not going to be useful to. But there was a report I think made by Polmed. I think Polmed came and they made inputs, but there were really no issues relating to the conduct of Polmed. I think Polmed in any event is administered at the time. They were administered by MedScheme, so whatever we find on MedScheme applies to Polmed, because that's what the schemes also do. They sort of aggregate to a single administrator, so the parties of that administrator are in fact, at some point, GEMS was administered by MedScheme itself. So the real reason was looking at the market size and the size of the schemes, giving you an indication of where the market trends might be. But also, this thing had to be practical. I mean, you couldn't go around looking for all 71 schemes. I think Minister. I also wanted to just thank the Minister for reducing the queue from 7 to 3.
And reopen your investigation. Is that fair? Yes. Okay. Yes. No, thank you very much. The first question, I think, is very obvious. What do we feel about discrimination, or what does the Minister feel? I think every South African should be ashamed of finding any pockets of discrimination 30 years after democracy. But you are aware that in reality, while the Constitution and all the acts are against discrimination, it's still happening. It might be one of the reasons why we want a national dialogue to refocus the country, because there are too many cases of discrimination which have been reported, some of them denied that there's nothing like that. But here today we have got the proof that there is live discrimination even among professionals. The people who are being punished here are professionals at the very high level of society, but there's still discrimination among themselves. So it shows that we still have far way of practicing what is in our Constitution and in our Acts. So we feel very bad about it. That's why we won't leave any stone unturned. I have just told you during my opening remarks that we had 14 departments of health. That's discrimination, obviously. We abolished them via the Constitution and we thought it's over, only to wake up today to find that we've got two different, not departments now. There's one minister. In those olden days, there were many ministers. There's one minister, but there are two systems. And inside those systems, there's discrimination, which today is actually being exposed here. The question from newsroom, what is the balance between NHI and the report? As I've already said, we've got health market inquiry, we've got this report, we've got NHI. There are areas where they intersect. There are areas where they show the direction which the country must take. So all the two reports, health market inquiry and this one, are going to help us a lot in sort of fashioning or designing a future healthcare system. The issue of cash, this question was asked for advocate, and he responded to it, how patients suffer. But I also want to remind you, there are three methods for paying for health in our country. And if I'm not mistaken, in all parts of the world, health care is paid for by three methods. The first one is called mandatory prepayment of health. You are paying for health before the person is sick, and it's mandatory. And that's what the NHI want to achieve. There are people who tell us that we are mad, there's nothing called free health care anywhere in the world. Nobody said anything about free health care. We said free health care at the point of service, that's all. That's what medical schemes are about. Medical schemes are providing free health care at the point of service for the people who are members. And in NHI, we want to do it for the whole population. That's mandatory prepayment of health. The second method of paying for health is called voluntary prepayment. That's what medical schemes are. You join me, like if you go to join Discovery, it's your own choice. It's voluntary. But you are paying for health before you are sick. Because if you wait for when you are sick, it will be a crisis. The third method is called fee for service, or out of pocket, or simply cash. And that seems to be a predominant method for the rest of, for most of the population rather, in South Africa. And when we said NHI, we want to run away from that. Fortunately, when we started the white paper, there was no health market inquiry by former Chief Justice Ngobo. Now the health market inquiry is there. And do you know what is in the recommendation? It says abolish this fee for service because it's a perverse incentive in healthcare. It disadvantages many people. That's in the report and we are going to implement it. Don't have people paying cash for healthcare because they are going to die in large numbers. The World Health Organization has even got graphs that shows which country is utilizing any one of these three methods more than the other. Any country that is utilizing fee for service more than the others is in trouble. And a country that's also utilizing voluntary prepayment more than mandatory is in trouble, which South Africa is. In that report, released in 2009 by the World Health Organization, the USA and South Africa were declared outliers when it comes to this method. Outliers because while many developed countries use mandatory prepayment, US and South Africa were more on voluntary prepayment and also on cash. And the World Organization is saying this is outlying outside what the governments are normally practicing because people are going to suffer. They will suffer, of course. The question you ask advocate about patient suffering because they have to pay cash was not only picked up by him, was also picked by Chief Justice Ngobo with his panel in the health market inquiry, that when you make people pay cash, they do suffer, and they suffer a lot. In my presentation on NHI, when I showed those graphs of the World Organization in 2009, there are two countries that demonstrate this. It's Sierra Leone and Guinea, where 90% of the payment for care for health is cash. What does it have to do with health and people suffering? Ebola. Ebola. How does Ebola relate to them? In 2013, when Ebola struck Sierra Leone and Guinea, it went for a long time without anybody detecting it. For a very long time, spreading in the population. By the time it exploded, it has been going on in the population without anybody detecting it. Was it a failure of science? No. It's because in Sierra Leone, 90% of the population, to see a doctor, they must pay cash. If they don't have cash, they can't go to a doctor. And if you have caught Ebola, it will spread. And you will suffer until you die, until it affects many people. So cash payment does not only affect individuals, advocate, it affects the whole population. Because that's exactly what happened there. It's a very clear demonstration. That's why on the graph on mandatory prepayment, voluntary prepayment, fee for service, the World Organization declared Africa a disaster in the making. That's the heading on those graphs for Africa. It said, Africa, disaster in the making, where lots and lots of people in the population are supposed to pay cash for health. It doesn't work. It has never worked anywhere in the world. So advocate, we accept that your finding is corroborating what former Chief Justice Ngobo find out, and we'll have to deal with those. The question was asked to Dr. Mabeba, as the chairperson of Council of Medical Scheme, whether they can make healthcare affordable. They are trying, just as a structure of the whole private healthcare system, as their regulator. But this is the job of ministers of health, of healthcare systems around the whole world, that healthcare ought to be affordable. And I've mentioned this statement when they said we are interfering. I said, if you go anywhere in the world and you find the minister of health who say as far as prices are concerned, the minister is neutral, then that minister must leave that seat. No minister of health must be neutral about affordability of health. Our job, our mandate as ministers of health is to make healthcare affordable to the population. That's a very serious and big mandate. So it's not only for the council, it's for the minister to make sure that healthcare is affordable. The motivation of us going to the Competition Commission in 2013, that led to the health market inquiry, was because I lodged a complaint with them that healthcare is not affordable, even for people who are working, even for people who are on medical schemes. It's no longer affordable. Please do something about it. I was not asking for health market inquiry. I was asking the Competition Commission if they can do something about this, the affordability of healthcare, which is running even from the middle class itself. Instead of doing that, the Competition Commission said, we want to prove whether what you are saying is true. Is healthcare unaffordable in the country? Let's prove it by doing an investigation. And they called that a health market inquiry. That's how it came into the being. They were investigating affordability because we have already picked it up. So we're not folding our arms. We were looking in the system and say, how do we improve it? And we thought it will take 6 months to finalize that report. But as I said, it took 5 years, showing the complexity of all these things that we're talking about here. The other question, that was asked from us is a remark made by the advocate here. Why the department or the government or the Council of Medical Scheme is doing nothing about some of these things. Advocate, the way the system works is this, and that's why if you read the NHI Act, we are trying to change it. The way the system works is this. The issue of billing and payment is between the doctor and the scheme. We don't come in between. People did not even believe it, that we don't even know, by the way. It sounds funny, but it's true. We don't even know where the doctors are practicing. There's no way of knowing. That's why in the National Health Act, we introduced the concept of certificate of need, which was attacked severely. A certificate of need is to know where the doctor is practicing, what is the doctor doing, what type of premises is happening. And that's why after losing it in court, because we lost this in court, just like the BHF which lost on the LCBOs, they appeal, we are also appealing, because we want to show the court, yes, we don't have the power to know where the doctor is. At the moment, the way the system works, advocate, when a doctor has passed medicine and they've got the certificate, they go to register with the Health Professions Council. That's professional registration. And they get a registration number. It's simply to say, we recognize you as a qualified medical practitioner. But for them to go and open a practice and be paid for by medical schemes, they need to get another registration number. They get that from the Board of Healthcare Funders. It's called a practice number. When you look at doctors' documents, it's written PR number. That's a practice number. Without that number, the medical scheme won't pay you. You can charge cash, of course, because we have got a registration with the Health Professions Council. But you need a PR number, which is given by the same council of, the Board of Healthcare Funders. There are people who have asked us, and we are going to ask industry, that number must be given by the Council of Medical Schemes, not by the medical schemes themselves, because they must give it with conditions. At the moment, the medical schemes give, themselves through Board of Healthcare Funders, gives a practice number. Now, the irony of it is that with that practice number, you can go and open anywhere. If you want to open your practice at the back of a bottle store, you can do so. If you want to practice at the boot of your car, you can do so. Sometimes back during apartheid, I was driving around Mpumalanga because I was working in Bushbuck Ridge. I found a white doctor seeing people under a tree. Somewhere around, when you pass Kanyamazana, going there. He was running his practice under a tree. And he had a practice number from the Board of Healthcare Funders. And he was charging medical aid because it doesn't show anywhere where your practice must be. And our certificate of need was to determine that. And of course, doctors said we want to bottle them, and they fought and all that. Solidarity took us to court, and of course they won. We are appealing because we think these things must be regulated. We must know where people are practicing and how. Then we'll also know these things. Lastly, advocate. We did not know that doctors are being cheated. As I told you, it's a relationship between doctor and their medical scheme. We only knew when they came to lodge a complaint with the Council of Medical Schemes. And the council recommended to me that in order for them to be able to understand this issue, we need this Section 59 investigation. Section 59 of the Medical Schemes Act allows a medical scheme to recoup their money if they think the money was acquired from them fraudulently by a practitioner. But it does not, as you're saying, outline the steps. It doesn't, because nobody foresaw that there will be this type of thing. So through the same Section 659, the council then requested the minister to appoint that committee. That's why we appointed you, to find out. Otherwise, we're in the dark. We will have known. If doctors didn't come and say, this is what's happening to me, they will have known. Me, during our time, these things were not happening. Because I told you, during our time, patients did not even have to sign anything. It just shows that as the system advances, it starts picking up problems, and very serious problems. So in our NHI Act, we're trying to deal with these things, advocate, because as you said, you have got 71 medical schemes. It doesn't end there. It doesn't end there. The 71 medical schemes have got 311 options. Options where they'll say, advocate, your option, we don't pay for this disease. All of them need to be administered. It's very complex. And that's why most of the money is going for administrators, not for GPs. The people who lodge a complaint here, if I'm not mistaken, I'm speaking under correction, I suspect most of them are GPs. Yes, most of them are GPs. And in these present situations, GPs are grossly undermined. It's a fact. Why are they undermined? They don't hold the power. Yes. The people who will be respected are specialists, because the medical schemes respect them the most, because most of their patients come from there, and because at their level, they are the ones who make private hospitals cheap, by the way. They are the ones who do so, not GPs. In the NHI, we clearly put it there that we are going to demand that patients must start with GPs. It's primary health care. And that is going to be very affordable. I'm coming to the issue of affordability, because I mentioned here when I was presenting NHI, if you go to a private hospital to do a circumcision, you are going to pay between 15 and 18,000 rand for a circumcision. If you go to a GP in the township, you are going to pay 1,800 rand. That's affordable. So why can't the minister say that? I mean, put for that, because basically doing a circumcision is not a matter of a specialist advocate. If you want to understand what I'm talking about. Yes. If you want to understand what I'm talking about, advocate. If somebody in a rural village come to you to say you must represent them in court because somebody stole your goat, their goat, what are you going to say? You're going to charge them more than the goat itself, it has been stolen. But that's what in healthcare we're doing. We're doing that. Yes. You want a circumcision, you go to a specialist who trained for 13 years, by the way. A person you call a specialist, for them to become a specialist, from the day they enter a medical school until they qualify as a specialist, is 13 years. Do you train a person for 13 years to come and do a circumcision? It can't be. It can't be. Those are things that must be done by GPs, and it must be compulsory that it's so. And that's why what you want to do in the NHI Act, it will bring the prices down dramatically. Because why is it 18,000 rand in a private hospital? Firstly, they are going to look for a urologist. That's a specialist who trained for 13 years. Then they'll put you under general anesthesia, which is very unnecessary, because circumcision are done under local anesthesia. They are going to put you under general, which means they need an anesthetist. And I saw black anesthetist here being targeted, but they are going to look for an anesthetist. Another specialist who trained for 13 years. Each one of them is going to demand 4,000 rand. That's their fee. It's their normal fee, so it's already 8,000. Then they will look for another doctor who is an assistant, who is not a specialist, but is a doctor with MBCHP, who will assist the urologist. That's another 2,500 rand. Then they'll charge you for oxygen. Then they'll charge you for the gases. Then they'll charge you for theater time. If the doctor is slow doing a circumcision for an hour, you'll be charged for that. Then they'll charge you for a swab, needle, drip, everything. It becomes 18,000 rand. Should we allow that type of a system? And the answer is, of course, no. That's why in NHI we say the GPs must be the first entry. In the same way that in the legal system, nobody wakes up to see you senior counsel. They come through attorneys. But in health, that has been cancelled. When I was a medical student, yes, that was the case. Nobody will wake up and just march into the offices of a specialist. You'll go to a GP and they'll refer you. If they can solve the problem, they solve it there at a very, very affordable cost at their level. But South Africa today has changed. Even an ordinary flu, you need a specialist who trained for 13 years. Even for a small cut, if a housewife is cutting some tomatoes and she gets a cut and she is on a medical aid, she's going to see a plastic surgeon for that. And the cost goes very high and we get surprised. So the changing of this system is a reality that we must be faced with. Whether we hate NHI or not, you must understand that there are realities in this same system. I mean, in this new present system that must be changed. And that's why we're here today complaining. Thank you.
Yeah, thank you, Minister, and the entire panel, and all of you. I guess we've come to the end of this press conference. We've been here for more than 100 minutes.